Birth certificates are mundane documents. Some would say boring. I would never say that. But I think they're documents that a lot of us don't think a whole lot about, except when we think, shoot, where is that thing? Because I need to go to the DMV or I need to apply for a passport and they want my birth certificate. And you rummage through your stuff until you can find it. Yet birth certificates have a tremendous amount of power to establish the legal facts of a person's identity. And because of this, they repeatedly pop up at the center of political controversies. So to just take a couple of examples from the news this week and last week, well, I mean, you might remember, some of you in the room may remember the flap several years ago in North Carolina over what became known in the news media as the bathroom bill. And this was a piece of legislation passed by the North Carolina legislature that required people in state buildings to use the bathrooms that corresponded to the sex on their birth certificate, right? So if your birth certificate says M, you got to use the men's room, and if it says F, you have to use the women's room. That law is no longer in force, but state legislatures at this moment are currently at work on many other bills that attempt to regulate transgender students' access to school programs by using their birth certificates. So one example of this is in South Carolina, a bill called the Save Women's Sports Act says that the gender of students on their birth certificates will determine whether they play on a boys' team or a girls' team in sports. In other states, that type of measure is accompanied by a companion piece of legislation which more tightly restricts the criteria that are used to allow a trans person to change the sex designation on their birth certificate. So an example of this was last year in Montana. The legislature passed, the governor signed two pieces of legislation, one that was essentially the same as the South Carolina legislation I just described, but it went along with another bill that elevated the standards for changing the sex designation on a birth certificate by requiring surgical gender reassignment in order to change sex designation. So those kind of, those work together to more tightly constrict the ability to change one's sexual identity, gender identity, and to make birth certificates the controlling mechanism for determining a person's sex. A little over a week ago, in Arizona, the governor signed a bill into law requiring voters to show proof of citizenship in order to vote. This joins Arizona's existing law enacted in 1996 that requires people who apply for a driver's license to show proof of citizenship. And when you look at the administrative regulations that make those laws function, right, the proof of citizenship, number one on the list, of course, is a birth certificate, right, which shows where you were born. And then if you don't have a birth certificate or you can't find it, right, you can assemble a variety of other documents that are considered to have less probative value than a birth certificate. Politicians and legislators who want to create boundaries around certain rights or categories of identity rely on birth certificates because over the past 2 centuries of US history, they have been transformed from a type of registry that was uncommon and hardly used into a nearly universal and standardized form of identification. They rely on birth certificates because the administration of so many of our rights, protections, and entitlements depends on being able to prove the facts about ourselves that these documents seem to be especially efficient at establishing. Namely, by showing where we were born, birth certificates can show that we are American citizens. Oh, I'm not advancing forward with my slide. Sorry, this is going to be clumsy. All right, I don't know why my slideshow's not working, but Doesn't really matter. What you were going to see was Barack Obama's birth certificate. Anyway, so by showing where we were born, birth certificates can show that we are American citizens and thus entitled to such things as passport, the right to vote, or even the right to be president. Birth certificates also show, as my earlier example suggests, right, that your biological sex. And until the last quarter of the 20th century, birth certificates also marked a person's race on their face. And they were very important, therefore, in the administration of policies of segregation. Virginia is famous for that. And in fact, I was excited when I got here to discover that I was in Rockbridge County, because this was the site of a tremendous amount of policing of racial classification on birth certificates. And I did research about that for my book. It's just I did it at the Library of Virginia in Richmond, where they have the Rockbridge County clerk's papers, but didn't actually make it here. But as I drove into town, I was like, oh wait, here I am in this place that I've written about. Anyway, so they were important for the administration of policies of segregation. They were instrumental in the allotment of Native American land under the Dawes Act and other pieces of federal legislation, and they are still in use to prove membership in sovereign Native American nations. Just as important, birth certificates show the date on which we were born. The modern bureaucratic state has come to rely on exact chronological age as one of the main gates in and out of all of our rights, protections, and entitlements. The right to school, to go to school, to drive, to vote, to work, to marry, to serve in the military, to serve in Congress, to serve as president, to obtain Social Security, to obtain Medicare, all of those depend on the exact elapse of time from the day you were born to the day you qualify for one of those things. And most of us, I think, take for granted that we have a birth certificate, and also that we're asked to use it in these ways, right? To prove these kinds of things about ourselves. We take it as given, not only that the document exists and that we have it, but that the agencies we interact with consider it to be a reliable source of information about us. But as Jill mentioned, I just finished writing a book about the history of birth registration in the US. Here it is. There it is, The Birth Certificate in American History. And my project in that book was to trace the 2 centuries long history of birth registration in the United States, to look at the way that registration system became a functioning system, which is really a story about state capacity, the ability of states to do this work of registering people when they're born. But it's also about the kind of intellectual and political desire to do that, right? Why do we care about doing that? Why do we want to do it? And it's about, so that's in part about different kinds of constituencies who want to have the information that birth certificates can give or birth registration can give. And it's also about publicity campaigns that convince ordinary Americans that they should want this too, right? That it's important to have these documents and to be recorded. I also look then at the variety of uses to which birth certificates have been put. Things I've already mentioned in the introduction here. And then finally, I close the book by looking at the contestation over birth certificates, particularly around issues of race and what is legally called birth status, right? Whether you're illegitimate, whether you're adopted, et cetera. And I look at the way that contests over the way those facts were recorded on birth certificates actually led to the certificates to be changed. Right, so we used to record race on the face of them, we no longer do. And so I look at how that played out. And I'm not going to go over that whole history here today, but what I am going to do is kind of dive into an episode that I think is really one of the most critical for understanding how the act of birth registration got transformed into a mechanism for establishing identity. And that is a case history about the enforcement of child labor law in the early 20th century. So that's what I'm going to talk to you about today. And I'm going to begin this story with a lament. So the year is 1898, and the lament is coming from the Wisconsin State Commissioner of Labor. So in 1898, Wisconsin had had a child labor law, a law restricting labor by age, for over 2 decades. Yet the commissioner complained in his annual report that the state could not enforce its law. This was because although the laws based the legality of employment on age, no one could say how old any particular child was. The problem, the commissioner explained, was twofold. First, he alleged that parents lied about their children's ages so that they could work. Second, this deception was made possible, he claimed, because Wisconsin suffered from what he wrote was a, quote, notable lack of reliable or complete birth records. Unable to rely on documentation of children's ages, state factory inspectors had to accept parental affidavits of age. That is, parents would go before a notary public, they would swear that their child was a particular age, the notary public would give a notarized age certificate that could be carried to an employer to gain employment. But the notary does not require that the parent provide any documentation of age. Rather, it's assumed that the parents are going to tell the truth because they're giving testimony to the notary under oath. But for the state labor commissioner, it seemed that this testimony-based system gave rise to widespread duplicity. The commissioner's complaints were typical. Wherever states relied on parental affidavits of age, child labor reformers, state factory inspectors complained nonstop that children's ages were misrepresented even when this sort of notary system was in place. So the solution, it seemed to those who wanted to effectively enforce child labor laws, was to find a more stable foundation on which to base the determination of age. So between 1900 and 1940, reformers successfully lobbied both state legislatures and the federal government to eliminate this affidavit system and to rely instead on paper records and government-issued documents, ranked in order of reliability. At the top of the list is the birth certificate. As a New York State agent of the National Child Labor Committee explained, the birth certificate was, quote, the most satisfactory proof of age to be obtained. The solution to the problem of enforcing child labor laws was, ironically perhaps, to shift the authority to authenticate a child's age away from the parents, away from the people who were actually there when the child was born. Professionally produced birth certificates objectified a child's age and identity, making a truth that existed apart from the personal relations that produced the child. The replacement of affidavits with documents represented a shift in authority, one that made age an objective fact, and one that gave state-produced documents the status of truth. Before I dive into the story of that important shift, I'll offer a really brief background on the history of child labor and the effects to curtail it, because I don't know, how familiar people are with the story. Historians disagree about exactly when childhood became a distinct category or when chronological age became the most important marker of childhood. But there is very widespread consensus, nevertheless, that it's in the 19th century that we get this sort of modern sentimentalized view of childhood. While colonial era children spent their days working, worshiping, and living alongside their parents, masters, guardians in a variety of kind of multi-age mixed settings, over the course of the 19th century, a host of institutions and legal regulations worked together to construct childhood as a distinct stage of life, to define it in opposition to adulthood, and to mark its boundaries by chronological age. The changing relationship of children to labor was one of the most important features of modern childhood. As the advent of market economies began to segregate home from work, and as middle-class families began to have fewer children, they came to regard the purpose of childhood as preparation for adulthood through education, not through household labor or formal apprenticeship. A developmental view of childhood combined with a romantic notion of children as essentially innocent caused middle-class parents to worry that premature labor would fetter or stunt or in other ways debilitate their children. So when this set of emerging ideals confronts the industrialization of work and the industrialization of the work that children performed in the years following the Civil War, child labor emerges as a moral problem in the United States. And national organizations to combat child labor are created. Organizations like the National Child Labor Committee, the National Consumers League, and others are formed in the late 19th century, around the turn of the century. And the earliest efforts to regulate child labor by age begin in the Northeast, where we also see the earliest industrialization of work, right? So it sort of follows that. And really from the 1870s through the 1930s, states all across the nation are passing a flurry of restrictive child labor laws. These are laws that regulate, what age you can work at, what type of work you can do, how many hours you can work at different ages, and so on. And even though the opponents of child labor, right, folks like from the National Child Labor Committee or the National Consumers League or these factory inspectors that I've been quoting, right, are often accusing working class parents of lying about their children's ages in order to circumvent these laws, their complaints also reveal that reformers and working class families understand age differently. For many working class parents, their children's ages are not a calendrical or chronological fact. And I think if you sort of read against the grain of some of these reformers' reports, you can see that. So in the 1887 report of New York State's very first team of factory inspectors, the inspectors write that they are shocked to find that in the factories they're visiting, quote, very few American-born children could tell the year of their birth. The same thing's happening in Connecticut in 1888. The factory inspectors there are going around, and one of them, named John Jennings, writes, "It is impossible to secure definite information as to the age of many of the children." And the problem, he goes on to explain, is that, quote, "in too many instances, the age of the children is merely a matter of speculation with the parents. They preserve no record, and their memory on the subject is worthless." It was not uncommon for enforcement officials to actually have to adjudicate conflicting claims about children's age between, say, a mother and a father, or between the parents and the child, right? So people in the family are not agreeing about how old a child is. Illinois' factory inspector, Florence Kelly, who later goes on to be the head of the National Consumers League, makes this observation, the same kinds of observations as the folks in Connecticut and New York. She writes that large numbers of foreign parents keep no record of births and deaths and literally do not know what to swear to in making affidavit to their children's ages. And this imprecision about age is not limited to the parents of working class children. So around the same time, late 19th, early 20th century, when census enumerators are going and knocking on everybody's door, they're asking them how old they are, and they find that people answer in intervals of 5 years. I'm 20, I'm 25, I'm 30, I'm 35. They never say I'm 27, I'm 26, right? Suggesting that people really have a pretty approximate idea of how old they are. Likewise, at polling places in the 19th century, very few people, when asked, could tell the poll watchers their birth date to verify their age in order to vote. And so, I think a lot of what's going on here is, again, not so much lying as it's not particularly important to know exactly how old you are. And that working class families are also making calculations about age in other terms, what sociologists would call functional and relational age. So a functional age would be what is your capacity to do something that's important, right? So in a working class family, and you see this actually in court cases about child labor, the parents will say, he was big enough to work. That's functional age. So a child reaches a certain size, a certain strength, a certain physical capacity, they are ready to work. Relational age might be you're the oldest boy in the family and your father is dead, so it's time for you to work. The relational age is, well, how are you in relation to the other people in your family, right? And this is all happening in the context of a kind of household economy, right, where everyone is a contributor, right? So these are just different ways of making sense of age, right? And they're no less sensible or rational than chronological age. So whether parents lied or just didn't know their children's ages, for child labor opponents and reformers, the effect is the same. Either way, using parental affidavits renders child labor law ineffective, and they believe, the reformers, denies children the rights and protections that those laws are supposed to afford them. So the solution, they believe, is to move away from affidavits and towards documents as a source of knowledge about children's ages. I'm just going to give it one more try, but it's really not going to work. I'm really not going to get my slides. Sorry. I did, yeah, that's what I'm doing now. Okay, I'm sorry. So beginning, as I said at the beginning, beginning around 1900, child labor reformers start lobbying state legislatures and then the federal government to change the rules about age certification. So they are urging states to reform the child labor laws they have on the books to require documentary evidence to establish a child's date of birth. Documents represent an entirely different system for generating the truth about age. Affidavits are the result of eyewitness testimony, or of eyewitness oral testimony, and they operate on the assumption that those people who are closest to the event are the most reliable source of information about it. And this actually comports with legal standards for evidence in 19th century courtrooms too. When age is a material fact in a case, the law prefers testimony over documents, right? Documents are regarded as sort of secondhand. Someone coming into court, taking an oath to swear the truth, is considered a better source of information, right? So if age were material, the person themselves under oath is considered a reliable source of information about that. Their parents are considered reliable sources of information. That is better than the family Bible or some other document that could be brought in. Documents, on the other hand, right, in contrast to affidavits, are generated and they're tended by institutions that claim a different authority over events. They claim authority on the basis of not being close to the event, right? And being removed is given the status of being disinterested, neutral, objective, right? So documents, these reformers hope, will tell the truth about age, fix it as something concrete, something absolute, something independent of the kind of family calculations that might be at play in reckoning things like functional or relational age. So they initiate this legislative reform in the states and then federalize the new standard. The kind of model law is passed in 1903 in New York, and it changes the procedure for the issuance of employment certificates to children. So in this law, it requires, you can no longer use an affidavit. If you have a birth certificate, that's prima facie evidence of age. If you don't have a birth certificate, your parent can swear an affidavit, but that affidavit has to be corroborated by some other lesser document. So you could bring in a school record, you could bring in a family Bible, you could bring in a baptismal certificate. And then if you have none of those things, you can get examined by a physician and have your parents also testify at the same time. But the only thing that stands alone is the birth certificate, right? So although it's documents in general are considered good, birth certificates are clearly, prioritized and prized above all others because they're the only ones that stand as prima facie proof. So an article covering this new law in the New York Times from 1903 writes, under the new law, the parent's word is not recognized as proving age. For every certificate issued, there is filed some official or religious paper as evidence of age. So after New York's law is passed, other states follow suit and adopt very similar protocols. So just 4 years later, by 1907, 18 states have passed legislation that require documentary proof, right, and have left behind that affidavit system. And by 1917, that's up to 39 states and the District of Columbia. And when child labor reformers are successful at getting federal child labor legislation passed, which they are in 1916 and 1919, they federalize these standards that were first promulgated in New York State. So both those laws were struck down. I'm sure many of you in the room know, the federal child labor laws were declared unconstitutional. But during the time that they were in effect, the enforcement authority for them was given to the United States Children's Bureau, and their chief task was to come up with a system for how to create employment certificates, federal employment certificates for children. And they viewed their chief task in that operation as figuring out how to verify the age of children, right? But what they did was they just lifted the standards from that New York law and federalized them. And so they gave first priority, right, to the birth certificate. So this was, those laws were struck down, but in the way that the federal government can today exert authority over the states, right, by creating standards for that they have to comply with, right? The same thing happens here, that when the federal child labor laws are in effect, the Children's Bureau will come in and enforce, will allow states to enforce the federal law themselves if they already have a law on the books requiring documentary proof of age. Then they're allowed to issue their own certificates. But if they don't, then the Children's Bureau will come in and they will do the issuing in those states. So what happens is that states, in order to avoid having federal officials enforcing the law in their states, they start passing laws that meet the federal standards, right? So even though the federal laws go away, the states have changed their own laws to comply with the federal standards, so they're still in place when those laws are declared unconstitutional. So it's had the effect of kind of nationalizing these rules, not everywhere, but in, probably 90%, 80, 90% of the states, right? So more and more you can see, right, that child labor opponents are identifying the problem of child labor law enforcement as a problem of inadequate birth registration. Reflecting on the Children's Bureau's experience enforcing federal child labor law, one of the Bureau's officials writes that, quote, "Age ought to be a fact which could be quickly and finally established. But as vital statistics have not been kept in a large part of the United States, much time must be spent in the search for proof of age, and in many instances, unimpeachable evidence cannot be obtained." So the problem they come to think is that birth registration, right? And birth registration in many states is incredibly spotty in the early 20th century. And among foreign-born children, birth certificates, even where they exist, right, can be very hard to obtain because they're in Russia, they're in Germany, they're in Poland, right? They're in England, right? Those actually places with functioning registration systems, but doesn't mean the kids have easy access to their birth certificates. So there's no national laws that govern birth registration or registration, and it's left to the states, right? And as a state and local matter, vital registration was uneven, irregular, and often really honored only in the breach. While some reformers interested in public health had been trying to improve state birth and death registration going back as far as the 1840s, by the early 20th century, birth registration in particular was still virtually neglected. In 1903, Congress creates a permanent Census Bureau. And as soon as the Census Bureau is created, they start trying to help the states improve birth registration. They create a standard certificate of birth so that there'll be a uniform certificate everywhere. And then they also write a model law for the states for vital registration. And they try to encourage the states to pass this model law. And one of the things that the model law, I mean, it kind of has rules and ideas for how you should make a vital registration system function, but it also includes language that says that a birth certificate is prima facie evidence of the facts contained therein, right? So it creates the birth certificate as an identity document. It makes sure to put that in there. After 1913, the Census Bureau is no longer working alone to try to improve registration in the states. I've mentioned them already, but the newly formed U.S. Children's Bureau, which is created by legislation of Congress in 1912, the first thing they do is they launch a birth registration campaign in the United States. For the creators and the staff of the Children's Bureau, birth registration was part of a comprehensive commitment to child welfare. And so they conduct this kind of multi-decade campaign to improve it in the United States. They stress in their publicity that birth registration benefits both individuals and society, right? And that it's essential to bolstering efforts to reduce infant mortality, increase compulsory schooling, and to stem the tide of illegal child labor. So the first head of the U.S. Children's Bureau is a woman named Julia Lathrop, and she writes, articles promoting the Children's Bureau in women's magazines and all kinds of different publications when it's first founded. And one of these, as she's explaining her agency to the public, she says that they wish to, quote, awaken America to its responsibility for publicly recording the birthdays of its children. Among the benefits of registration, Lathrop cites the increased ability to ensure that, quote, no parent shall be tempted to make a false statement as to a child's age. Lathrop clearly understands, right, that birth registration and child labor law enforcement are intimately connected. So during the same years, right, that the Children's Bureau is enforcing federal labor legislation in the states, it's also campaigning for better birth registration across the states. And beginning in 1915, it works with a whole variety of sort of non-governmental organizations like the General Federation of Women's Clubs, and state federations of women's clubs, the Association of Collegiate Alumni, which becomes the AAUW, the American Association of University Women, and they go around into communities across the country, and they conduct these things that they call birth registration tests. And what the tests do is, so they get these volunteer women, and they say, we're going to go knock on every door in a neighborhood. They'll create a kind of district that they're going to do the test in, and you're going to ask at the door, is there any child here under the age of 1 year old? And if the people say yes, they're going to record the information about that. And then, once the district is fully canvassed, they take all these yeses back to the Vital Registration Bureau in the town, and they compare the yeses to the birth certificates on file. And this gives a snapshot of how accurate is birth registration in this community. And so these are campaigns that are designed to create useful statistics about the accuracy of birth registration, but also they're really kind of promotional in that as the people are knocking on doors, they're explaining to people, why should you care if, the birth was registered of your child, right? And so this is just one of many kind of like grassroots, community-based organizing and publicity campaigns that the Children's Bureau is doing really from the 1910s through the 1930s. To try to promote registration. And so during the time that they're doing this, the number of states that register like 90% or more of live births goes from 10 to 22. And then Congress passed a law called the Shepard-Towner Act in 1921, and that gives money to the states for to prevent infant and maternal mortality. And a lot of the states, at the kind of urging of the Children's Bureau, use Shepard-Towner funds to promote birth registration in the states. And so during the time that the Shepard-Towner funds are being used to promote birth registration, that number goes up from 22 to 35. So by 1930, like 35 of the then 48 states are doing a pretty good job registering their births. And finally in 1933, all 48 states are regarded as having good registration, which is to say 90% or more of live births. Now, even in 1940, 1950, if you drill down into that and you look at birth registration, say, by race, or urban versus rural, or midwife versus physician-delivered births, you're going to find huge discrepancies, right? So even in like 1940, like among the Navajo, like 40 to 50% of births are registered, even though the states in which the Navajo live, Arizona, New Mexico, might be regarded as having 90% or more of the total population, right, of live births are being registered. So it's still quite variegated, even though it's considered to be fairly complete by the 1930s. From the point of view of reformers in organizations like the National Child Labor Committee or the U.S. Children's Bureau, better birth registration made for better child labor law enforcement. But from the point of view of many working class families, the shift from affidavits to documents was a bitter pill. By the time that the first federal child labor law took effect in 1917, parents and children and enforcement officials in the northern and midwestern states had had a decade or more of experience with a documentary system of age verification, because remember, that starts in like 1903 in New York and then spreads across the North and Midwest. But in 1917, when the Keating-Owens Act, the first federal child labor law, is starting to be enforced, many southern states still required only parental affidavits of age. Thus, for many southern families, the new federal proof of age standards came as a shock. In Georgia, Children's Bureau officials denied an employment certificate to a boy whose life insurance policy listed him as younger than his mother claimed him to be, right? So they were requiring her to bring in to bring in documents to support her claim. She brought in this life insurance policy, and it says the boy is born in a different year than she claims, right? And the Children's Bureau goes with the life insurance policy. And she is outraged. And she writes a letter to the Children's Bureau promising to sue them, quote, to test whether a mother's word will not hold in court, right? And you can see, as I've mentioned, that, she's aware that testimony in court and that her word is supposed to have legal weight, right? And that is a completely viable way to think. And so she just can't understand how it could be otherwise. Likewise, an obviously frustrated father from Tarboro, North Carolina, a man named J.A. Rideout, wrote to the Children's Bureau asking why the Bureau would, quote, accept evidence obtained from people who don't know only what they was told, when he, unlike such outsiders, quote, am in a position to know his son's date of birth. So he's contrasting the secondhand knowledge, right, that the Children's Bureau wants to rely on with his own firsthand knowledge of his son's birth. And he's, like the mother from Georgia, having trouble believing that what he regards as secondhand knowledge would carry greater weight than his firsthand knowledge. What parents like Rideout did not understand, but what they quickly learned, was how profoundly laws passed at the state and federal level altered their autonomy over their children. Birth registration made age absolute, and it shifted authority from families to documents and from oral to documentary forms of knowledge. As soon as it began promoting birth registration, the Children's Bureau received scores of letters every year from mothers and fathers who wanted to know whether their children's births had been registered. Some of these parents were concerned to secure evidence of birth to use as proof of age for employment. In 1921, for example, a woman named Mrs. Louis Bergeron of Chicago, Illinois, wrote to the Bureau asking for, as she put it, information concerning the birth registration of my two boys. She reported that the Catholic Church in which she had had them baptized and which had recorded their baptisms had been burned to the ground, and so she did not have their baptismal records, and she did not have, as far as she knew, they did not have birth certificates. The boys, she explained, quote, need to work, for we are poor people and 8 children in the family. So Bergeron clearly understands the rules, right? She knows that she needs to supply state employment officials with some kind of documentary evidence of her boy's age. And she explains it really well. She writes, "They all claim for those paper because they are law." And she noted, "I am under the law." That parents like Mrs. Bergeron wrote the Children's Bureau seeking help in locating birth certificates, and that they tied the matter to employment is a measure of how much had changed since 1898, when Wisconsin's Commissioner of Labor complained that he was helpless to enforce child labor law because proof of age rested on testimony, not documents. When he wrote in 1898, age verification was almost entirely in the hands of parents throughout the nation. Though Wisconsin law, like many at the time, required parents to swear affidavits, they were not required to supply documents. And unless a labor law enforcer could themselves supply some alternative source of information, some alternative facts, right, these affidavits are entirely impossible to disprove. In 1921, by contrast, when Mrs. Bergeron is writing the Children's Bureau, it's she who is helpless to prove her children's ages. The Illinois law requiring documentary evidence of age had been in effect for 18 years when she writes. Significantly, Mrs. Bergeron does not claim she doesn't know how old her children are or when they were born. Rather, she recognizes that she lacks the authority to make her knowledge, however accurate it might be, recognizable to the state. She was under the law, and she needed the paper. Reformers subjected parents such as Bergeron to these changes because they believed public birth records could remove all taint of interest and any possibility of deception from the process of age verification. The information they contained was normally supplied by those outside the family. So a lot of state laws require that it be the birth attendant, right, that fills out the birth certificate. And the sort of the time relationship, right, between the filing of a birth certificate and when a child wants to go out to work is sort of broad enough to remove incentives to lie, right? Whereas when a parent walks in at the time they want a child to work, they have an incentive to lie. Just as important, birth certificates presented information in a uniform and standardized way, one that made the knowledge they contained stable and easy to authenticate. The public birth record, wrote the Children's Bureau in 1916, affords absolutely unimpeachable and uniform proof. The official record of one state is accepted in all others, right? And so that's important, the kind of uniformity of it. That makes the facts stable, it makes them easily verifiable. One of the things these people didn't like about things like family Bibles and other sources of information is that they're totally irregular. Everyone looks different from every other one, and they say, I don't know if this is, this person could have written this in here yesterday. I have no idea, right? So they're not uniform, they're not stable, and therefore don't seem objective. Strictly speaking, birth certificates were falsifiable, since retroactive birth registration was and is permissible. Indeed, the more important birth certificates became to proof of age, the more people clamored for delayed or post hoc registration. In the wake of the campaign to make child labor law rest on documentary proof of age, many states and localities also began to require it for enrollment in school. Registrars and county clerks in states like Virginia used birth certificates to enforce laws segregating schools and other public facilities and to bar interracial marriages. And when the federal government initiated Social Security, it asked for birth certificates to prove eligibility for benefits that depended on both age and kinship. Likewise, when the United States entered World War II, the federal government required that all workers in defense industries provide proof of their citizenship. And this creates this gigantic clamor for delayed birth certificates. So the more protections and entitlements that states and the federal government offered, the more important documentation became to the functioning of social institutions. A Census Bureau employee named Robert Lenhart wrote in 1940 that, quote, each step we take toward the goal of social and economic security for everyone makes more precious each individual's proof of his rights to such benefits. In making the birth certificate the threshold of modern citizenship, child labor law led the way, transforming the grounds for rights and protections for both inclusions and exclusions. And so when we bring forth our birth certificates at the DMV, we live in the world that's been created by this history I've just told you. So too do the legislators who attempt to fix gender fluidity by pinning it immutably to the box ticked at birth on the birth certificate. Like the case of child labor law, these new laws are about who has the right to affirm, affix, or amend identity. Power and knowledge, then as now, are bedfellows. Thank you. Happy to take questions if people have them. We're sort of at our end time, but we also started late. I don't know how you want to run things, Jill.
If we have a question or two?
Yeah, if anyone has a question, I'm happy to answer. There's also lots more I can tell you about birth certificates that's not part of this talk, so if you have questions, there's like some legal arcana that I don't know the answer to, but you know.
And this might be one. How in your research, how long ago did American states or counties or whatever, or governments start certifying that people were born?
Yeah, good question. I can actually answer that one. So all the North American colonies, when they're colonies, have some kind of registration laws on the books, and that's because, so Virginia does in Dale's Code, going back to the beginning of the 17th century, there is a law requiring that births, deaths, and marriages be registered, and that's a parish-based system. And so it models like the parish-based registration system of England. What I think is really interesting about, there's a law, but most people don't do it, right? Because in those kind of cases, like you, the head of the householder, you've got to like walk down to the parish and register the birth. And in the Massachusetts Bay Colony, by contrast, I mean, one of the things that's interesting about the Massachusetts Bay Colony, so in their 1642 Body of Liberties, which is sort of their equivalent of the Dale's Code, their governing set of laws that they create the first civil registration system in the modern world. So it is not a church-based system. It's a civil registry system that is, so registration is done through the town clerk, right? And so, those laws are there from the beginning, but they're not enforced. Registration is really spotty, and then when the colonies become states, right? They also put these laws on the books, but around the late 1830s, early 1840s, I alluded to briefly, people who are kind of interested in public health start to look around and say, we just don't know anything about the birth rate, the infant mortality rate, even the death rate, because we just don't have good vital registration of any kind. And so they start trying to work to improve it. But it takes basically a century to get from there to, as I pointed out, 1933 is when the 48 states are all considered to have 90% or better live birth registration. So it's a long process, and I think there's a variety of explanations for it, but the answer in short is that all of them have the laws from the beginning.
So any of our so-called founding fathers who were born on American soil would maybe have a birth certificate, or maybe not?
They might have, they might not have. The funny thing, I mentioned Julia Lathrop, she's the first head of the Children's Bureau, and she's out there promoting birth registration, and I did some research in her papers, and she didn't have a birth certificate. And when she was applying for a passport, she had to go around, getting other information to establish that she was a citizen, right? Never mind how old she was. So, it was. I would be shocked if any of the founding fathers had a registered birth. Maybe Adams, because he was born in Massachusetts. Massachusetts was a little bit better, but. Probably not.
Yeah. I'm just curious.
Yeah, sure their families had records of it for sure,
right.
because these are literate kind of elite families. They would have written it down for sure, and that was good enough for most purposes.